Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, January 8th, 2026 at 9:04 in the morning. So we're beginning our day today with our legislative council with Siegel. We're going to, I know we walked through this last year, but I think just need a refresher. Ask Rick to walk us through again, H211. So Rick, good morning. Thank you for joining us. Good to see you again. Hope you had good holidays.
Good morning.
Able to relax while we were gone.
Rick Siegel, Office of Legislative Counsel. The relaxing stopped around late November, when the deadline started coming in. But I did have a restful summer. I hope you all were able to have some rest and forget about this for a little bit. But it's good to be back. And if I'm here, it's going to be a technical bill, probably, that has a lot of IT definitions or AI definitions, and this one is no different. And Mr. Chair, I don't remember a walkthrough. Maybe we did.
I don't
We
think
have,
Yeah, we did.
211.
I don't think we did.
Okay.
Yeah.
Yeah.
But even if we did, this bill, I had to look at it again. Like, what is this bill? So it's been a year since I worked on the bill. So forgive me if something comes up that I don't have a quick answer to, but obviously it's a very detailed bill. Speaking of data brokers, and I do want to kind of set the stage a little bit before I talk about the bill. We did have some data broker related bills last session, the Daniels Law. Remember that one? 342, I think H 342. That one involved data brokers, but it wasn't this specific type of regulation of data brokers. And Vermont, as I said last year, was the first state to regulate data brokers. Other states have now done that. Some states, like California, has introduced a really pretty large regulatory system over data brokers and also giving consumers the right to basically opt out or delete. It's called the Delete Act. California actually, I believe January 1st, their system is now live. So if you live in California, you can go to the California, I think they have some privacy agency website, and you can actually register and then drop. I think the system's called DROP. DROP probably stands for something if it's government, probably an acronym. You can go in and you can basically notify data brokers that you want your personal information to be dropped, to be deleted. So that's what this bill kind of does. We'll talk about in detail what it actually in words on the paper does. But I also want to say, if you want on your computer to pull up Title IX, Chapter 62, that's where this bill is. It's a pretty, it's not called data privacy, it's called protection of personal information. That's Chapter 62. It might as well be data privacy. This is the most that our titles get into when it comes to data privacy. And this bill does not include every section in that chapter. So if you want to have that pulled up, just in case I want to reference another section in that.
What section?
So Title IX, Chapter 62, protection of personal information. That's where the age appropriate design code was also placed in last year. Okay, so let's do a walkthrough of the bill. The definition section. Now, again, we have laws on the books that pertain to data brokers. So a lot of this bill is amending existing either definitions or laws. In some cases, we'll have new sections, but you'll notice that a lot of these definitions are already on the books. We're just updating them in various ways. On page 2, bottom of page 2, and then on the page 3, you have a new definition of authorized agent, and this is a person designated by a consumer, which is a Vermont resident. That's all a consumer is here. To act on the consumer's behalf, a parent or legal guardian that acts on behalf of the parent's child or on behalf of a child for whom the guardian has legal responsibility, or a guardian or conservator that acts on behalf of a consumer that is subject to a guardianship, conservatorship, or other protective agreement. This bill, the statutes previously referred to as third party, and you'll see that. And this definition is not replacing third party, but in some ways it's giving an option for a consumer to designate An agent could be a company, could be a person to help them with their personal information. Okay. Biometric data is actually in the current statutes, but it's not defined as anything specific. This is providing a very detailed definition. You may recognize this as it appears in, I think it was in the age appropriate design code. I'll double check that, but it's definitely in data privacy laws that we've walked through here. So it's data generated from the technological processing of an individual's unique biological, physical, or physiological characteristics that is linked or reasonably linkable to an individual, including iris or retina scans, fingerprints, facial or hand mapping, geometry templates, vein patterns, voice patterns, and gait, or personally identifying physical movement or patterns. Biometric data does not include a photograph, an audio recording or video recording, or any data generated from any of those two items. Okay, broker personal information is an important definition. Not much of a change here, except you'll see that one of the characteristics of that is biometric data. Because we have now defined biometric data in this bill, we mark out, strike through how it currently is defined, which you can read that through the strike through. It includes a few things like fingerprint, retina scan, but the proposed definition is much more thorough than what is currently in the books. And then adding phone number as brokered personal information. Currently, it's not in there. Although your name and address is currently in there. Brokered personal information does not include publicly available information to the extent that is related to a consumer's business or profession. Kind of a curious exception there. We can talk about that later, but it's currently on the books. Okay, definition of business is pretty much.
Can you repeat that? Because I missed what you just said.
So it's the top of page 5. Brokered personal information, what it does not include? Does not include publicly available information to the extent that it is related to a consumer's business or profession. So if you're a lawyer and your name and information's online, that would be permitted as not publicly. I mean, that would not be brokered personal information because it's your professional information. That makes sense. Mm-hmm. So definition 4, business is pretty much any entity, and you can see all the ways we define that currently, except for state entities and any vendor working for the state. So a state or a political subdivision of the state would be not a business when it comes to this chapter. And let me also take a step back. These are all chapter definitions. Okay, these apply to every statute section in this chapter. So keep that in mind too. The proposals to add controller, consumer health data controller, and processor to business. One could argue that those 3 are already included in that long list. They are likely either a partnership, a corporation. They're probably one of those already existing. However, it doesn't hurt to be specific and ensuring that those 3 are included as a business. Six, a consumer health data controller means a controller that alone or jointly with others determines the purpose and means of processing consumer health data. A controller is a person who alone or jointly with others determines the purpose and means of processing personal data. The definition of data broker does not change a whole lot. So I'm going to read it because it's important here. It means a business or a unit or units of a business. And so think about the definition of business, okay, that we just went through. Several are together that knowingly collects and sells or licenses to third parties the brokered personal information of a consumer with whom the business does not have a direct relationship. Okay, so examples of a direct relationship include if the consumer is a past or present customer, client, subscriber, user within the last 5 calendar years is the proposed change. So some kind of limitation. Right now, there's no limitation on when you were a customer or a client of the business or the data broker. Employee, contractor, or agent, investor, donor. The following activities conducted by a business and the collection and sale or licensing of brokered personal information incidental to conducting these activities do not qualify the business as a data broker, developing or maintaining third-party e-commerce or application platforms, providing 411 directory assistance or directory information services, providing publicly available information related to a consumer's business or profession, providing publicly available via real-time or near real-time alert services for health or safety purposes. The phrase sells or licenses does not include a one-time or occasional sale of assets of a business as part of a transfer or control of those assets. That is not part of the ordinary conduct of the business, or a sale or license of data that is merely incidental to the business. Any questions about the definition of data broker?
Are nonprofits, 501(c)(3)(4)s included in that?
They could be, because they would be a business. And then if they do one of these things, if they collect and sell or license to third parties, they could be a data broker.
Businesses considered. Okay, never mind.
So an affiliate of a data broker,
Yeah.
would they be a data broker?
Like if there's multiple businesses that they have, is that considered? Is transferring the data from one business to another considered?
They would be a processor, right? So would the processor be, this bill, I think would make sure that they are, because they would be considered a processor if, yeah. But something for me to think about. That's my 99% answer, but still 1% chance that this doesn't always include every affiliate you can come up with. Data broker security breach. This is used one time in the current statute. Basically, when the data broker registers annually with the Secretary of State, part of that form asks them, have you had a security breach? And we'll get to this bill really kind of expanding on that quite a bit. Not the definition, but there's a new section just specifically dedicated to data broker security breaches. So I'm going to scroll past this for now, but it's not super relevant to the current way the statute is set up. So on to page 8, data collector, which is not a data broker. A data collector is a bit more broad of a term. It means a person who, for any purpose, whether by automated collection or otherwise, handles, collects, disseminates, or otherwise deals with personally identifiable information, not broker personal information. Those are different definitions. And this does include state. So state entities would be considered a data collector if they collect personal information, which would be your name, which most state agencies do in one way or another. I'm going to skip through encryption and license. Login credentials on page 9. Just correcting grammatically, stylistically, there's no hyphen in email. So we fixed that. 14A, personally identifiable information, is a consumer's first name or first initial and last name in combination with one or more of the following elements. When the data elements are not encrypted, redacted, or protected by another method that renders them unreadable or unusable by unauthorized persons. So again, it's your first name or first initial and last name in combination with one or more of these. So your social, your driver's license number, again, you can read all these, military ID, passport, a financial account number or credit or debit card number, password, no changes here. The biometric data, removing the current definition that is in the statute and just referencing the new definition, proposed definition, excuse me, genetic information, and so forth. So this is personally identifiable information. Subdivision 15, a new definition. We recognize this precise geolocation means information derived from technology that can precisely and accurately identify the specific location of a consumer within a radius of 1,850 feet. Definition of processor, a person that processes personal data on behalf of a controller. Grammatical change to redaction. Security breach 19A. Good to go over, but not necessarily needed for the walkthrough here. Okay, any questions about the definitions?
Just want to be sure that any definitions that we're using in here are the same definitions that we put into other bills that we put through the statute.
So as far as in this chapter or just in general, just
Well, in general, like, you were talking about the biometric.
right.
So is that the same language that we have in, we passed it in the kids code and just want to be sure that whatever we're putting in here, that we either update other areas so that we're consistent.
For so there's a amendment that's being worked on that matches everything up.
Okay.
Yeah.
All right.
So this is kids code, not in effect yet, so obviously,
Right.
but it's on the website. One of my duties towards when we're getting towards the end of the bills is to make sure they all line up. Thank you, something I'm aware of in general, but especially here. And it's kind of an office-wide AI. There's so many definitions of AI that we need to settle on something. So just as an example. Okay, so under current law, Vermont has a Security Breach Act that requires if there's a security breach of a data collector, which includes the state, right? And most businesses, if you have a security breach, you have a requirement to report that to not just to the consumer who was affected by it. I think we've all gotten the letter, right, that your data has been breached, whatever. Most states have some form of this. And there's also a requirement for the Attorney General or DFR to be alerted if you are a collector that meets the definition and Vermonters' data has become breached. You have to notify the consumer and the appropriate state agency. So under our current subchapter 2, we have the Security Breach Notice Act. A small amendment here, subsection H, the enforcement mechanism. The current language is with respect to all data collectors and other entities subject to the subchapter. And then the rest of the language talks about how if you're registered with DFR or the AG, you have you must notify them or you have enforcement. The proposed language is with respect to a controller or processor. So we're going from data collector, which is very broad, to controller or processor for the Security Breach Notice Act. Same language elsewhere, speaking of the AG has authority to adopt rules. If you are a financial entity, same thing. You must report to the DFR and they have the authority to adopt rules. So again, the main change here is going from data collector to controller or processor. You're narrowing the scope of who meets this definition for enforcement purposes. Questions about this? Okay. 2436 is a brand new section, and this almost mirrors exactly the Security Breach Notice Act, which I just showed you a couple of sections at the end. So this would apply to data brokers. Data brokers are not specifically mentioned in the Security Breach Notice Act, just data collectors. Right? Sometimes a data broker is a data collector, not always. And the types of breaches they may have are different. So this would be specific to data broker breaches, okay? Subsection A, this shall be known as the Data Broker Security Breach Notice Act. Again, different from the Data Security Breach Notice Act, it's data broker. Subsection B, notice of breach to consumers. In fact, I think I want to change that when we amend this, if we do amend this, to notice of breach, because this applies to the AG too, not just to consumers. So it's something I need to fix. Subdivision 1, except as otherwise provided in subsection C, a data broker shall, following discovery or notification to the data broker of a breach affecting a consumer, notify the consumer that there has been a data broker security breach. Notice shall be made in the most expedient time possible and without delay, but not later than 45 days after the discovery or notification, consistent with the legitimate needs of law enforcement, or with any measures necessary to determine the scope of the breach and restore the reasonable integrity, security, and confidentiality of the data system. So you have that 45-day timeline, but it's a little bit squishy because law enforcement can say, hold on, this is an active investigation, or something else, which we'll talk about here, could come up. So not just to the consumer, but the subdivision 2, a data broker shall provide notice of a breach to the AG as follows. They shall notify the AG of the date of the breach and the date of the discovery of the breach, and shall provide a preliminary description of the breach within 14 business days, so a much shorter timeline to notify the AG. Consistent with the legitimate needs of law enforcement. If the date of the breach is unknown, they shall send to the AG as soon as it knows the date. Subdivision 3, unless otherwise ordered by a court for good cause, a notice provided under the subdivision, which is the AG, shall not be disclosed without the consent of the data broker to any person other than the authorized agent or representative of the AG, state's attorney, or another law enforcement officer engaged in legitimate law enforcement activities. When the data broker provides notice of the breach to a consumer, that's what subdivision 1 is, the data broker shall notify the AG of the number of Vermont consumers affected, if known to the data broker, and shall provide a copy of the notice that it provides to the consumers to the AG. So you're kind of carbon copying the AG on that. The data broker may send to the AG a second copy of the consumer notice from which is redacted the type of brokered personal information that was subject to the breach that the AG shall use for any public disclosure. So they don't have to, they may do it. It's up to the data broker if they want to send that information. The notice of the AG and a consumer shall be delayed upon request of law enforcement. They may request delay law enforcement if it believes that notification may impede an investigation or jeopardize public safety or national security. In the event law enforcement makes the request for the delay in a matter other than writing, the data broker shall document the request contemporaneously in writing and include the name of the law enforcement officer making the request and the agency. A law enforcement agency shall promptly notify the data broker in writing when the agency no longer believes that it may impede a law enforcement investigation or other national security issue. The data broker shall provide notice required by the subsection without unreasonable delay upon receipt of a written communication, which includes facsimile or electronic communication from the law enforcement agency withdrawing its request for delay. Okay, back to the consumer notice. It shall be clear and conspicuous that the data broker makes to the consumer. A notice to the consumer of the breach involving brokered personal information shall include a description of each of the following if known to the data broker. The incident in general terms, the categories of brokered personal information that was subject to the breach, the general acts of the data broker to protect the brokered personal information from further security breach, a telephone number that the consumer may call for further information, advice that directs the consumer to remain vigilant by reviewing account statements and monitoring free credit reports, and the approximate date of the data broker security breach. A data broker may provide notice of a breach involving brokered personal information to a consumer by 2 or more of the following methods. I think that should be a shall. Let me fix that real quick. 17. Okay, so subdivision 5, it really should say data broker shall provide notice of a security breach involving brokered information. Written notice mailed to the consumer's residence, electronic notice for those consumers for whom the data broker has a valid email address. If the data broker's primary method of communication with the consumer is by electronic means, the electronic notice does not request or contain a hypertext link to a request that the consumer provide personal information. And the electronic notice conspicuously warns consumers not to provide personal information in response to electronic communications regarding security breaches.
Can I ask a question? So, or sorry, sorry. Just out of curiosity, because of chat talk stuff. I am curious. So, since the data breach stuff also applies to governance, I'm curious. I'm not seeing anything in here that would make it so it seems like it has to be in writing or some kind of thing, like just vocal telling somebody in person. And a thing actually doesn't, I'm not seeing anything here that would just allow that kind of thing, right? Like.
For the state.
Yeah,
So a data broker does not include the state.
okay, no, yeah, no, breach, the
The previous.
Yeah.
So this is section, this is a new section, right?
Okay.
2436, 2435 applies to data collectors, which includes states. The state, excuse me. So section 24 up here, this one that we only briefly amended, this one here
Yeah,
applies to the state.
yeah.
So,
So
but the language is
notice
similar.
goes,
Yeah.
yeah, okay, it's similar, okay, great.
It's similar.
Okay,
So if
okay,
you
okay.
want,
Okay.
the committee wants to amend that applies to states, you need to amend that section.
Okay, cool, thank you.
Okay, so we're on page 17. Here we go. Okay, 18. We're talking about the notice to a consumer by two or more of the following methods: written, electronic, telephone notice on line 6, provided that telephone contact is made directly with each affected consumer and not through pre-recorded message. Or D, notice by publication in a newspaper of statewide circulation. I'm trying to think of what that means in Vermont.
Do we have a
That's,
statewide publication?
that's kind of what I'm thinking. If we may need to work on this. Because I imagine this would be a method that they would want to use, publication by newspaper, because it's fairly easy. So I think we may want to,
GovOps updated that in open meeting law, so we could use that.
cross-reference it. Okay. In that statute?
In that statute,
Okay. That term statewide circulation?
as that was how you had to publicize a meeting, an agenda in the minutes, and so I believe that would be a good, Tucker's probably.
Yeah, we might need to play with that a little bit. 'Cause like,
Accepted.
yeah. It's like we do that in like planning commission, but it's only a regional newspaper because you're not out, if you're outside of Milton, it doesn't
Right.
really apply to you. This, you're dealing with people, I mean, they could be all over the state.
Right.
But newspapers, I mean, like the Times Argus technically is.
Online.
It's on.
Yeah.
But. You know how.
Well, this doesn't
How does that go?
does this preclude electronic publications?
So that's one of the options, but it's got to be an email. So you directly email the consumer.
And it's two of these four.
Two of these four. So either written via snail mail or electronic email, telephone. It's got to be it can't be a pre-recorded message. Or D, statewide circulation of a newspaper. So I think we can work on this. It just needs to be clear to the data brokers what they need to do. Yeah. Okay, exception, notice of a security breach pursuant to subsection B, which is the big. When you go back and look at subsection B, that's where all the notice requirements are. is not required if the data broker establishes that misuse of brokered personal information is not reasonably possible, and the data broker provides notice of the determination that the misuse of the brokered personal information is not reasonably possible pursuant to the requirements of the subsection. If the data broker establishes that misuse of the brokered personal information is not reasonably possible, the data broker shall provide notice of its determination that misuse is not reasonably possible and a detailed explanation to the AG. Data broker may designate its notice and detailed explanation to the Attorney General as a trade secret if it meets that definition. If it establishes that misuse was not reasonably possible under that subdivision and subsequently obtains facts indicating that misuse of the brokered information has occurred or is occurring, then it must provide notice pursuant to subsection B. In other words, if you make the determination and then you turn out to be wrong, you then have to go back and actually provide notice to the consumer and to the AG that your information is being misused. I would think about on subsection, as I'm looking at this again, subsection C, there's not really any timelines here, so remember they have 45 days to alert the consumer and 14 business days to alert the AG if there was a breach. So at some point during that 45 days, if the data broker realizes that we don't think that this thing happened, right? The breach happened, however, we don't think that misuse occurred. It might help to explain define what misuse is. How does the data broker know? Like if I'm advising a data broker, I look at this, I'm like, well, I don't quite know if it was misused. Is it that the data was leaked, it was breached, but then no one got a hold of it? Like the breach was closed up so quickly. I think it would help to have that further explained of what that misuse looks like. Up to you all, but. And it's reasonably possible, again, kind of squishy language here. Something to consider for an amendment. Okay, page 19, waiver, subsection D. You cannot waive this notice. You can't hide this in terms of agreement that you don't have to provide notice of the breach. Subsection E, enforcement. This is very similar to the security breach language that is being amended by this bill. Controller or processor. That is not governed by DFR. The AG has the authority to adopt rules and also conduct investigations, et cetera, that bring it into the Consumer Protection Act. If you are a entity that is licensed or registered with DFR, then DFR has the right to adopt rules and conduct investigations, et cetera. Okay, any questions about the data broker security breach notice act? Okay. So subchapter 5 is currently in the books, but there are several proposed updates to how data brokers are regulated in the state. Currently, very lightly, you must register, as I said, but then after that, there's not a whole lot of regulation happening with data brokers. So registration, again, they currently must register once a year on or before January 31st if you meet the definition of a data broker. Currently, you pay a registration fee of $100 every year. So this language would amend that and say that you pay a registration fee in an amount determined by the Secretary of State, which shall not exceed the reasonable cost of establishing and maintaining the website set forth that we'll talk about here in a little bit, a new website, and establishing, maintaining, and providing access to the accessible deletion mechanism, also set forth later, which we'll talk about. And be deposited by the Secretary of State into the Data Brokers Registry Fund, which is a new fund that would be established in this bill.
Before you go on, so right now, a broker can collect data for 13 months before they have to register in the state, and we can amend that right now. Like that's part of what we're talking about here.
So this language will not change that, but you can.
They could collect data for 6 months, 8 months, 10 months. And then keep that data and never register, and we would never even know under law today.
And then would they stop operating in Vermont? Is that how they'd get away with? Yeah. So even if
Open a new
you,
company and do it again.
if you,
That's a good thing. I mean, you see, like, I mean, I get 5 spam calls a day and these people, you chase them down and within days, they just start a company.
so the way the law is written now is if the data broker operates for even one day in Vermont, they would have to register at some point before January 31st of the next year. So right now, if there's a data broker that comes into Vermont and they operate for one day and they leave, they would have to register by next January 31st, right? And are they? I don't know. Talk to the AG about that, but
When we talk to the Secretary of State, we'll have to understand why the following year after they've been opted.
Yeah.
That was a discussion.
That does seem very excessive.
John,
So we're changing from a flat fee to something determined by the Secretary of State. Does anyone give you any notion of what that would be?
that would be a Secretary of State question.
Yes.
And you'll see that I assume the reason why is because there's going to be some expenses from the Secretary's office if they have to implement some of these things that are coming up, but I don't know what that would look like. Okay, page 21, we talked about the new fund, the Data Brokers Registered Fund. That would be established and all the money of registration would go into that fund, and you'll see some more money being put in that fund here in a little bit. Subdivision 3, so when you register, you do have to provide some information to the Secretary of State's office about who you are, like your name, email, phone number. Your phone number's new. Email and website are still there. If you, so again, this is current law. If you, as a data broker, permit a consumer to opt out of the data broker's collection of brokered personal information, opt out of its databases. Just if you allow an opt-out process to your consumers, you don't have to, but if you do, the Secretary of State wants to know. If the opt-out applies to only certain activities, whether the data broker permits a consumer to authorize, here you see an authorized agent taking the place of a third party, kind of being more clear that the consumer can have this agent opt out for them. A statement specifying the collection, databases, or sales activities for which a consumer may not opt out. A statement whether the data broker implements a purchaser credentialing process. The number of data broker security breaches that the data broker has experienced during the prior year. If known, the total number of consumers affected by the breaches. So this is the current notification to the Secretary of State about a breach. The consumer is not going to know directly unless the data broker wants to let them know. So, just for your background, this is kind of the limitation of what the data broker would provide to the state is like how many times has it happened. Where the data broker has actual knowledge that it possesses the brokered personal information of minors, a separate statement detailing the data collection practices, databases, sales activities, and opt-out policies that are applicable to the brokered information of minors. Okay, this is new, subdivision G. Whether the data broker collects precise geolocation, consumers, reproductive health data, social security numbers, driver's license, biometric data, immigration status, sexual orientation, or union membership of consumers. Beginning on January 1, 2031, whether the data broker has gone through an audit, which is new, get to that language in a second. And if so, the most recent year that they submitted a report resulting from the audit. Beginning January 1, 2029, the following metrics, and this is going to refer to the delete mechanism coming up. The number of deletion requests received, the number of deletion requests processed. And these are consumers that are requesting their data be deleted. The number of deletion requests denied because the consumer request cannot be verified. and the number of deletion requests denied because retention of the consumer's brokered personal information is required by law. And then J is any information the data broker wants to provide if they want to give the state more information. Penalties. Currently, if you don't register as a data broker, it's a penalty of $50 per day, not to exceed a total of $10,000 for each year. An amount equal, again, this is proposed to be struck through, but I want to read it just so you can see the current law. An amount equal to the fees due under the section during the period it failed to register, and then other penalties that may be imposed. So the new penalties proposed are this. Still administrative fine of, I'm sorry, this is new. An administrative fine of $200 for each day the data broker fails to register. So it goes from 50 to 200. An amount equal to the fees that were due during the period the data broker failed to register. Any reasonable costs incurred by the state in the investigation and administration of the action as the court deems appropriate. Still talking about penalties here. A data broker that fails to provide all registration information shall file an amendment that includes any omitted information not later than 30 days after receiving the omission from the Secretary of State, and is liable to the state for a civil penalty of $1,000 per day for each day thereafter that they don't provide the amendment. A data broker that files materially incorrect information in its registration is liable to the state for a civil penalty of $25,000 and shall correct the incorrect information not later than 30 days after notification of the incorrect information. And if it fails to correct the information, an additional penalty of $1,000 per day for each day the data broker fails to correct the information. All penalties, fees, fines, expenses are going to be deposited into the data broker's registry fund. Okay, enforcement, adding the Secretary of State as an entity that can enforce the penalties or fines that are imposed in this section. D is new, a public web page. The Secretary of State shall create a web page where it lists the registration information provided by data brokers pursuant to the section and the accessible deletion mechanism set forth. So I think that they do have a website currently that lists there's a data brokers. This just requires it ongoing and also requires the deletion mechanism, which is next. Questions about that section? Okay. 2446A, accessible deletion mechanism. On or before January 1, 2028, the Secretary of State shall establish an accessible deletion mechanism that implements and maintains reasonable security procedures and practices, including appropriate safeguards appropriate to the nature of the information and the purposes for which the brokered personal information will be used, and to protect a consumer's brokered personal information from unauthorized use, disclosure, access, destruction, or modification. Allows a consumer through a single verifiable consumer request to request that every data broker that maintains any brokered personal information about the consumer delete the brokered personal information. Allows a consumer to selectively exclude specific data brokers from a request. Allows a consumer to alter a previous request made to subdivision 2 at least 45 days after at least 45 days have passed since the consumer last made the request, so you can change your mind. Allows a consumer to request the deletion of all brokered information related to that consumer all at once through a single deletion request. Permits a consumer to securely submit information in one or more privacy protecting ways as determined by the Secretary of State to aid in the deletion request. Allows a data broker registered with the state to determine whether a consumer has submitted a verifiable request to delete the information related to that consumer. Does not allow the disclosure of any additional brokered personal information of a consumer when the data broker accesses the deletion mechanism unless otherwise specified. Allows a consumer to make a request described in subsection 2 of the subsection using a website operated by. So just making sure consumers have the ability to do it. does not charge a consumer to make a request, is readily accessible and usable by consumers with disabilities, supports the ability of a consumer's authorized agent. Maybe be singular there. Supports the ability of a consumer's authorized agent to aid in the deletion request. 13 allows the consumer or their authorized agent to verify the status of the consumer deletion request. Provides a description of the following: the deletion permitted by the section, the process for submitting a deletion request pursuant to the section, and examples of the types of information that may be deleted. Subdivision B, or subsection B, data broker access. Beginning August 1, 2028. So this is the deletion mechanism is January 1, 2028. And then that August, a data broker shall access the deletion mechanism at least once every 45 days and shall process all verifiable deletion requests that it's received in the previous 45 days and delete such information. Process a request as an opt-out of the sale or sharing of the consumer's brokered information. Direct all service providers and contractors associated with the data broker. So Greg Booten talks about maybe affiliates, right? In this case, that this is more specifically if you are a provider and contractor with us, that you delete all brokered personal information related to a consumer who has made a verifiable request and process a request as an opt-out of the sale or sharing of the consumer's brokered personal information. And do not use or disclose any information submitted by a consumer through the deletion mechanism for any other purpose besides the authority provided in the subsection, including for marketing. A data broker may deny a request if retention is required by law. The Secretary of State may charge an access fee to a data broker to use the mechanism that does not exceed the reasonable costs of providing access. Any fees collected shall be deposited into the data broker's registry fund. Continued obligation to consumers. Beginning August 1, 2028, once a data broker has processed a verifiable request to delete a consumer's broken information, the data broker shall delete all information to the consumer at least once every 45 days unless the consumer alters the consumer's decision. Retention of the consumer's broken information is required by law, and they shall not sell or share new brokered information of the consumer unless the consumer expressly requests otherwise in writing. Subsection D, audits. A data broker shall undergo an audit by an independent third party. This is not defined, something to think about if you want to be more specific on what you want there. To determine compliance with the section at least once every 3 years, with the first audit taking place on or before December 31st, 2030. For an audit completed, the data broker shall submit the report resulting from the audit and any materials related to the Secretary of State within 5 business days of a request from the Secretary of State. A data broker shall maintain all reports and materials for 6 years. Subsection E, rules. The Secretary of State may adopt rules, implement the provisions of the subchapter, except it shall not be permitted to create a rule that establishes a new fee that is not authorized within the section. Penalties. A data broker that fails to comply with the requirements of this section is liable to the state for an administrative fine of $200 per day for each deletion request the data broker fails to complete, and reasonable expenses incurred by the state in the investigation and administration of the section. And then again, all fees, fines, etc., go into the fund. 2446B, the data broker registry fund, is established in the state treasury. It shall be administered by the Secretary of State. It's not yet clear. All money collected or received by the Secretary of State and the AG pursuant to the subchapter shall be deposited into the fund and shall be made available for expenditure by the Secretary of State upon appropriation by the General Assembly to offset the following costs. So this money can only be used in these ways. The reasonable cost of establishing and maintaining the website, so that accessible deletion website. The costs incurred by the state courts and the Secretary of State in connection with enforcing the subchapter. And the reasonable cost of establishing, maintaining, and providing access to the mechanism, deletion mechanism, as described in section 2446A. Okay, finally, 2446C credentialing. A data broker shall maintain reasonable procedures designed to ensure that the brokered personal information it discloses is used for a legitimate and legal purpose. These procedures shall require that prospective users of the brokered information identify themselves, certify the purposes for which the information is sought, and certify that the information shall be used for no other purpose. A data broker shall make a reasonable effort to verify the identity of a new prospective user and the uses certified by the prospective user prior to furnishing the user brokered personal information. And a data broker shall not furnish brokered personal information to any person if it has reasonable grounds for believing that the brokered personal information will not be used for a legitimate and legal purpose. So section 2447 is something I think you all should look at, even though it's not in this bill. It's on the books, and it is one thing that data brokers have to, it's a informational, make sure I get the words right here. So currently data brokers, they must register, which we talked about. They also must create this comprehensive informational security program, okay, which is enforceable by the AG. I don't know if the AG has enforced this at all. You can ask them about that, but there is currently at least one duty that data brokers must adhere to under state law. And that's this information security program, keeping the data secure. So that's not touched in this bill. But maybe you want it to be touched. I would take a look at it and see if you like the way it's written. It would take effect, we would need to change that upon amendment, presumably to 2026, but up to you all what you want to do. What a way to start the year.
Did it in the
Yes.
allotted time.
That's, you
a
know-
really good way to start the year.
Yes.
That's a-
Is that internal clock?
That's right. I just kind of know. And there's a clock on my computer. You know, that I keep an eye on. Okay. Questions?
The fund that's created only assists the Secretary of State's office in the courts, right? But
Right.
it doesn't assist the Attorney General's office if they have to prosecute.
Right.
Of that. Right. That fund, which is Secretary of State, I think for the Attorney General's office as well. But
There was a provision that can,
John.
I'm sorry.
go ahead, heard the memo.
Seems to me, I remember there was a provision in there that allowed them to recoup the costs, but the AG can recoup their costs from the data broker, but not something different than what you're talking.
Well, I mean, if we're creating a fund.
Yeah.
That is there to pay the Secretary of State's office back for whatever they have to do. Should be open to the AG as well. Yeah, we'll take a look at that. Jonathan?
Hi, I think my question pertained to, I think there's something also on page 30 in that same spot. I recall there being something about records retention for 6 years. Can we go back to that section?
Yep, on line 13.
Yes, what
Resolution 3.
I'd be curious about is what are they holding for 6 years? Does that contain consumers' protected information? And is that something else that is also at risk of being breached? I'm just curious about hearing more about what is being retained for 6 years.
So it's the audit that is done by this independent third party that the data broker can select And, is it subject to a breach? I guess, if they keep it on, a server, that is, available to the public, it might be breached. I think that the purpose of that language is so the Secretary of State can get it if they need it. They can pull it from the entity. I don't know if 6 years is a specific reason for 6 years. You can change that, I suppose. But yes, to answer your question, it would potentially contain brokered information that a consumer would not want to be breached.
Okay, if audits by independent third parties are like a standard known thing of, well, here's what it will include, that would be good for us to know. Or if each independent third party will perform it according to its own specifications or, customary activities, that I'm just curious about how that's, if that's just as at risk as anything else, or not. Thank you.
Yeah, I mean, the audit, there's not a lot of language on the audit. So if you want to beef up the audit, that's something you can talk about. Because it's basically that, like I said, you undergo an audit for compliance with the section. It's a very, pretty detailed section. But it's not really, you're not giving the auditor much to go on here, and or how the report should look and what information should or should not be in the report. If you want to be more prescriptive, I would suggest that you do so in statute. Otherwise, it's really up to the independent third party to determine what should be compliance and what's not.
So a data broker gets notification, say we have a button on the website, and they get a notification, they have to remove data for the person. If that data broker is one that is maintaining criminal records, would that include the removal of that?
Well, that would be publicly available information, I would think.
But it's accessed through the data broker.
Right.
So therefore,
And probably required by law to maintain that information. So if it's information that the data broker must keep by law, in the statute, it says you don't have to delete that. I don't know the laws on criminal information, what is required to be kept online and what's not. But I would imagine a lot of that is required by state and federal law to keep the criminal records.
well, I suspect that if it's a data broker that's specifically designed to pull data for organizations, they don't maintain the actual records. I mean, the state would retain.
Right.
But they would have like the pingable option, right? Like you could ping them for it and then they would say, oh yeah, there's criminal records. We can grab them.
It's like a background check kind
Yeah.
of situation. I can't respond to the technical aspects of that. I can tell you that, there's a couple of exceptions and one of the exceptions is required by law, but that may not cover what you're concerned about. I don't know. It may be helpful to get a witness in here that could be more illustrative of what that process looks like and what they would say based on the language. Like, do we think this language prevents that or does not? That's what I can say about that.
So it's not just deleting, but if as far as the law goes, they can't delete it, but is there not, would they still have the ability to share it?
Through this deletion mechanism, if a consumer requests data be deleted, one of the explicit, if you look at page 28, you delete all the information at least once every 45 days. See one. Yeah, you not sell or share new brokered information. So delete and not just delete, but also not sell or share. So that's in there.
Or you could still have the information it's covered under law, that you can't read it, but
Right,
can't sell or share it.
right, right.
Would be the likelihood of putting, or ability to put in like an exception for organizations that are regulated by DFR? Some other federal agency.
We make exceptions all the time, so you just want to talk about what you want to exclude, and we make sure the bill includes that and make as clear as you can. Because those exceptions, they become very important, right? As our definitions, and you want to make sure that if you all agree, a majority of you agree on something, that you want to make that explicitly clear what you're trying to exclude. So yeah, we can answer your question.
Just for clarity, what I'm talking about is for organizations that are regulated by DFR or, some sort of financial organization on the federal level. Will be able to access the data in those data brokers, not a very like front-facing websites that an individual can go on and just pull the information. Like, I 100% am okay and on board with, you should not have access to that if somebody doesn't want it. It's those transactions that are happening on, like, from Bank of America, from insurance companies, those kind of things, I'm very touchy.
I could just add to that. I see your point and I agree with it. I mean, I was looking at I think it's a Series 69 or something like that, where it was talking about stocks versus banking and insurance. And they specifically carve out banking insurance because you're already regulated. So I think what he's looking for is, can we say in this, if you are already regulated by some other organization, these rules do not apply. But let's take the sex offender registry, for example. I mean, I'm going to use that because if a sex offender says, well, I want my name expunged, is that going to make a person who they may be moving in next to, is it going to make it a lot harder for them to find out if that's the case? Maybe they have small children or something like that. And we certainly don't want to do that. And I don't want them to go on a website to see if this person moving in is a sex offender and to say, oh, yeah, we're sorry, we can't tell you that. That name's been deleted. Now, maybe it's on the state site, but now we put the onus on this parent who's concerned about their children to go and find that information. And we're making it a lot harder for them to do that.
I think that's covered under public records, and that you can't request deletion of a public record, but we can get more information.
I would agree, but I can't again say 100% for sure, but that, I think that's not the intent of the bill, but certainly we need to make sure that that's what the committee wants, that you don't.
Right. Now, I know that's not the intent, but I think it's important that we make that very clear in this bill.
Questions? at this point? One question for you, Richard.
Yep.
President has signed an executive order in the states to regulate AI. Is that right? Can he actually do that? Does it stop us from putting laws in?
So this bill would not be affected,
Right.
Are you asking just kind of separately?
AI?
So I looked at the order. It's been a few weeks. I looked at it when it was signed. If it were upheld as a constitutional use of authority, then yes, because it clearly preempts the state's use of AI, and you have to go through this bureaucratic process to have your AI approved by some council that the White House is setting up. But my legal analysis would show that it's probably not a constitutional use of his authority, because the president has the authority to enforce federal law, right? That's the executive order power. There is no federal law regulating AI. There's not one federal law that addresses AI or data privacy. So to me, it's like, what are you enforcing? Are you enforcing the right of the federal government to preempt state law? That's not really a thing. You have to have a federal law so again, I'm not the authority on it, but my advice to you and other committees is you shouldn't stop what you're doing just because of an executive order that's not been adjudicated yet. And it will be. I assume there are lawsuits already filed.
So it doesn't preclude us from doing work on those
Right.
bills and
Right.
taking testimony. Maybe it just stays on the wall until they figure this out.
Right. Now, enforcing that, if you do pass a law, and you enact it and whatever, I think that executive order talks about penalties if you do it. And that's something to talk about, but you're not there, That's my advice. Do you want a more in-depth? Because I would need to prepare I can do a walkthrough of the executive order. I would just need time to prepare for that.
I'm also happy to, there's a webinar tomorrow NCSL is hosting, but there's
Yes.
also, I'll also through Future Caucus, like organizing a EO kind of thing. I'm happy to like line up witnesses if you want, just for a couple to like go over it and support with Rick if that helps, like.
I'm doing the NCSL thing as well.
Yeah.
I think it would be helpful
Okay.
for us to understand that start delving into the realm of AI this year that we want to make sure we're not preempting. Thank you, Rick.
Thank you. Yeah, good to hear that. Good to see you. Yeah.
Is in the hall.
Why don't we take a little break and come back with